Hello and welcome to this next video on medical law, and with me Charlie Medcalf, part of the medical law series on the Law with Charlie YouTube channel. I'm Charlie Medcalf and I am your host, and it's great to see you back here. So today we're going to be looking at medical negligence, and in particular we're going to be exploring the topic of duty of care. Now before we get started, this lecture presentation is one of my free versions, and so it doesn't go into as much detail as my premium versions do, and so if you want to really succeed and do your very best and also reach those higher marks, then I would highly recommend that you go and take a look at my premium content, where you will be able to get much better materials than this. This is just, as I say, the free version, which means it's more comparable to revision lectures, but this is a good starting point whether you are a law student like myself or just a member of the public interested in this area of law. But let's get straight into it now that we've got that bit out of the way. So, learning objectives. So by the end of this lecture you should be able to describe when the doctor-patient relationship begins. You should be able to describe when non-doctors will be held liable in medical negligence cases, and you will be able to explain when doctors will owe a duty of care to a third party. Also, I do apologise, but going back to a point I just made about this being the free version of the premium content, they have additional slides, additional details, additional content, etc. You will see that there are some extra details on these slides as well. However, I will not be spending much time on them, or at least not any more time on these free ones, whereas in my premium content I'll be going into much more detail and depth. So, as is the first substantive topic, as I had planned for the medical law content, here are some key questions which are important for medical law as a whole, but are also really important for medical negligence. So, whom does medical law involve, and whom is medical law for? So that's an interesting, they're two both very interesting questions to consider, and particularly when we get onto the causation part of the medical negligence, it might be interesting and useful to keep those in your mind. So there are a number of policy considerations for medical negligence. For instance, we have to bear in mind the limited resources available and the problems of if we allow the floodgates to open. But that's an example of content which I will be discussing much more in my premium content. But let's go straight into medical negligence. So hopefully you may have gone through the law of tort already and have come across the tort of negligence. So negligence is an element of tort law, and the structure in medical negligence is pretty much exactly the same as tort. So you essentially need to, the person you're trying to sue needs to owe you a duty of care. You must be able to show a breach of that duty. Then you need to establish causation, and that's both factual and legal causation. Now, causation in particular is a particularly difficult topic often for students, but so we will start at duty of care naturally, logically, and essentially with all these elements we would very much start off on the basis of tort law, the generic cases, and then we move on to essentially more medical law specific cases and more medical law specific rules, and that is particularly the case when it does get to causation. So looking at duty of care, when does this duty come into being? And we can see by law Justice Denning in Cassidy in 1951 that the duty of care begins in a medical setting whenever so the hospital usually, or GP or doctor, accept a patient for treatment, and they must use reasonable care and skill to cure him of his alignment. So essentially, as soon as you walk into the hospital and they accept you as a patient, they owe you a duty of care. Now, what about casualty departments and Good Samaritans? When are casualty departments under a duty of care, and when are Good Samaritans under a duty of care? Well, essentially, the basic position here is that casualty departments are under a duty of care when you present yourselves to them. However, for Good Samaritans, I am just someone who's trying to be useful. They are not under a duty of care automatically to do anything, but then if you did go ahead to offer support, then there may be a negligence claim if you do something wrong. However, usually your good deed is taken into consideration and will often, depend on the circumstances, have an impact on your potential liability. So another case where this kind of law comes out is by Mr. Justice Neild in Barnett from 1969, where it was clarified that a casualty department, when a person presents himself at that department complaining of illness or injury and before he is treated and received in the hospital wards, and that's essentially when a casualty department owes a individual a duty of care, so when the person presents themselves and before he is treated and received into the hospital ward. What about seeking out specific services? So if a patient seeks a particular service, does the doctor owe a duty of care in medical matters beyond the specific services requested? Now, this depends, as this next case shows us. This is the case of Carner Meadows in 2021, where Lord Legate identified that where the doctor recognises or ought to recognise a condition which poses a material risk to the patient, then their duty will generally extend to that risk. So the basic position is doctors aren't under a duty to consider matters which they have not been asked for advice on. So if I went to the hospital, for instance, and I told them that I had sore throat, but I also had a broken leg, they wouldn't necessarily be under a duty to deal with my broken leg if I just went there asking for help with my sore throat. That's not to say they wouldn't help me with my leg, but technically they don't owe a duty. However, if whilst examining my throat they saw that I had a serious material condition such as cancer, then their duty would likely extend to disclosing that risk to me and doing something about it because of the bad nature of cancer. So that's essentially the basic principles of duty of care. Now the next questions are, can other employees owe a duty of care, and if so, who are they? So who else may owe a patient a duty of care, and can non-medical staff owe patients a duty of care? And the basic answer is to both of those questions, yes and yes. So in Kent and Griffiths, it was confirmed that the ambulance service can owe a patient a duty of care. So once the ambulance service are available, both in the form of an ambulance and in the form of manpower, the resources to provide an ambulance on which there are no alternative demands, the ambulance service would be acting perversely in circumstances such as the present if it did not make those resources available. So essentially, and to draw briefly on the facts of the case, where an ambulance has been called for an emergency, if the caller is led to believe that the ambulance is on their way, then the ambulance and service technically owe a duty of care, and so as soon as both an ambulance and personnel staff are available, they should get to the person. So that's another medical related person, but what about a complete, arguably lay person? And this was seen in Darnley, where it was held that a receptionist can be owed a duty of care. And so the standard required is that of an averagely competent and well-informed person performing the function of a receptionist at a department providing emergency medical care. And in this case, this was all about a receptionist who provided incorrect information about waiting times, and this resulted in the claimant essentially going home, walking out because he didn't want to wait, and I believe he later died, so it was his estate which brought this claim. But essentially, because it was a head injury, he would have been seen sooner anyway, and so the receptionist's failure to mention this was problematic essentially, and that meant that the receptionist owed a duty of care. And despite owing a duty of care, it often won't be the individual themselves, it will often be like the hospital who is vicariously liable. However, the exception to this is where it's a GP, because GPs are personally liable. So another case example is the case of Wiltshire, where Nicholas Brown mentioned how a health authority which so conducts its hospital that it fails to provide doctors of sufficient skill and experience to give the treatment offered at the hospital may be directly liable in negligence to the patient. So this builds on the case law and the case law which is to come, how the health authority needs to ensure that doctors are able to provide a sufficient skill, and there's no lower skill for trainees essentially, but it's just one standard of care regardless. And this is important if you think back to the days of law of tort, for instance the Nettleship case, where it was held a learner driver owes the same duties and responsibilities as a fully experienced, fully qualified driver. Another example is also Bull and the Devon Area Health Authority, and in this case there was a woman in labour with twins, and she had to wait an hour for a registrar to arrive. The courts often do not want to interfere with policy decisions regarding allocation of limited resources, and this is particularly important when we're thinking of the NHS, which is funded by the taxpayer, and so they are famously provided with limited resources. But essentially the hospital, despite the courts not wanting to interfere with policy decisions, the hospital were held to be negligent because the delays were so substantial, and it obviously caused harm. So this case is really showing us how, even though the courts may not want to interfere with policy decisions in certain areas, there will be those exceptional cases where the courts decide they don't really have a choice and they need to find a hospital negligent, for instance. So another case is a case concerning a failed sterilisation, and this is the case of Fake and Morris. And it was essentially here that Lord Justice Neil, said that a reasonable person would have expected a reasonable medical man to be intending to give a guarantee, so he would not consider this to be the case. So essentially what's going on here is that essentially a doctor will not be negligent if the treatment doesn't actually work out. So here, as you can probably tell, was a failed sterilisation case, and so the doctor, if he was a reasonable, responsible medical man, then that's essentially enough. The doctor is not under a duty to guarantee that the sterilisation in this case will be successful, and so providing that they get the informed consent and follow all those requirements, which we will be looking at later in this course, and that they do the procedure in a reasonable manner, in a non-negligent way, then they will not be negligent if the procedure fails. So in this brief free basic talk on the duty of care in medical negligence, we have discussed, and you should now be able to describe when the doctor-patient relationship begins, describe when non-doctors will be held liable in medical negligence cases, and explain when doctors will owe a duty of care to a third party. So that now concludes our lecture on this topic. So please do remember to like, comment and subscribe. By liking, it shows me that you like these videos and that there's a demand for these videos, and this then motivates me to provide more content like this for you. Please do comment as well, whether it's a question you may have or anything at all. Please comment, because I do respond to every comment. And absolutely, if you haven't done so already, do subscribe to the Law with Charlie YouTube channel so you don't miss any of my content, including other lectures like this in both medical law and other areas of law, and also my various podcasts which I publish as well. As I say, if you have any questions, please do put it in the comments section below, and please do support me. You will find links in the description of this video and pretty much any of my videos on how you can support me, and that includes buy me a coffee, going on to the easy fundraising app, and that one is particularly useful because that doesn't cost you an extra penny at all. But when you shop online, by activating the easy fundraising, the business will donate a proportion to my cause at no extra cost to you, which is really useful. And also my premium content, and if my premium content is of particular interest to you, let me know in the comments section below. And if you have any questions regarding my premium content, again, let me know in the comments section. But if you thought this was useful, then the premium content is 10 times, 20 times more useful, because we'll be going through all of this in much more detail, looking at more examples, looking at more critical analysis, etc., and essentially all the key details you need to get the best possible grade in medical law. And so, as I say, this concludes this lecture, and next we will start looking at breach of duty in medical negligence, and then we'll move on to causation. So I hope you've enjoyed this, and I look forward to talking to you again very, very soon. And hopefully you will come back for more of these videos. And if you are particularly interested, check out some of the videos which are currently available, shown on my screen now. Goodbye.